The U.S. Court of Appeals for the 11th Circuit just dismissed the appeal on the Kraken lawsuit down in Georgia that was filed by Sidney Powell. Hi, welcome back to Legal Briefs. I'm Wes Austin. I'm a lawyer and comedian and keeping us updated on the latest legal news. So this lawsuit is the one that is being referred to as the Kraken that was filed down in Georgia by Sidney Powell. And we just had a decision last night by the 11th Circuit. Today is December 5th, Saturday. I'm hoping to post this today. The opinion was just posted last night from the 11th Circuit. Now, there was a very narrow issue up on appeal to the 11th Circuit, which was, did the district court enter an order that the 11th Circuit had jurisdiction over? The 11th Circuit said no, it was not. So they dismissed it for lack of jurisdiction, and they are sending it back down to the district court. All right, let's just dig into this a little bit. I know, I like to use the word dig. I can't help it. So this lawsuit was filed on Wednesday, November 25th, and they were alleging that the presidential election results in Georgia were suspect because of some vulnerabilities in their Dominion voting software, as well as because of some mathematical and statistical anomalies in Georgia. Then, on Friday, November 27th, they filed asking for a preliminary injunction, and here were the things they were specifically asking for. So they wanted a temporary restraining order preventing the defendants from erasing or altering forensic data on voting machines. They also wanted an injunction decertifying the presidential election results, or alternatively a stay in the delivery of the certified results to the Electoral College. And lastly, an injunction making the voting machines available to plaintiffs for forensic analysis. So the judge had a hearing on Sunday night for this motion, and I believe the plaintiffs agreed to a limited order to where they were going to order 2 or 3 counties to not destroy any of the data on any of the Dominion voting machines or software. I think they originally wanted maybe 10 counties to have this order, but they agreed to this more limited 2 to 3 county order. So the judge, he gave them what they wanted. He issued a restraining order ordering these 2 to 3 counties to maintain the data, to not destroy or erase any of the data on these voting machines. And he also issued an order to get the contract between the state of Georgia and Dominion voting systems. So, and he also granted a hearing on December 4th so that they could go over more evidence. So great. The plaintiffs were getting what they wanted. Things were going well. So they appealed. Yeah, that's where I got confused. Now, I am not the only one that was confused by this, because it looks like the 11th Circuit was also confused. Let's just look at some of the language from the opinion. In this case, the district court issued an emergency temporary restraining order at the plaintiff's request, worked at breakneck pace to provide them an opportunity for broader relief, and was ready to enter an appealable order on the merits of their claims immediately after its expedited hearing on December 4, 2020. But the plaintiffs would not take the district court's yes for an answer. They appealed instead. Yeah, they were confused too. They're like, I bet you that judge was confused. Like, you know what? I agree with you guys. I'm gonna grant this order. Let's look at the evidence. Yes, I agree. We appeal, Your Honor. I mean, did you? So the only question before the 11th Circuit was, did the district court enter an order that we have jurisdiction over? And they said no. Let's just quickly look at the reasons why. The Sunday night order is not appealable under 28 U.S.C. 1291 or 1292A1. So the 11th Circuit gave 3 reasons why this is true. They said, first, the district court didn't deny the plaintiff's request at all. So that's the first reason. Secondly, we normally don't have jurisdiction over TROs. And thirdly, the order from the district court judge on Sunday night is not a preliminary injunction masquerading as a TRO. So those were the 3 reasons given on why they didn't have jurisdiction under either one of these sections. Okay, the 11th Circuit also said the Sunday night order is not appealable under 28 U.S.C. 1292B. Now, regarding reviews under this statute, this is what the 11th Circuit said. Review under this statute was intended and should be reserved for situations in which the Court of Appeals can rule on a pure controlling question of law without having to delve beyond the surface of the record in order to determine the facts, and should not, in contrast, turn on case-specific inquiries such as whether the district court properly applied settled law to the facts or evidence of a particular case. All right, I'm not going to dig into that one any more than that because you're going to get bored. But anyway, they didn't have jurisdiction under that statute either. And in conclusion, because we lack jurisdiction, the appeal is dismissed and the motion for permissive appeal is denied. All right, so here's my take on this. This is purely procedural. The 11th Circuit didn't comment at all on the substance of the case, so it's just purely a procedural thing. It's going to go back down to the district court. We're going to have to see if this district court judge is pissed off now. I don't know. I think he was giving the plaintiffs what they wanted, and then they appealed. So I don't know if now they go back down, he's going to be like, oh, I remember you guys. You wanted stuff to appeal on? I'll give you some stuff to appeal on. Or maybe he'll not be pissed, but I might be a little pissed because I was, dealing with them, giving them what they wanted, and then they're like, we appeal! Now, I would like to say that the 11th Circuit here showed some nice judicial restraint in just talking about the issue before them, right? Unlike the Third Circuit opinion. Do you remember that thing where the Third Circuit went off on all sorts of just whatever? They did not just stick to the one issue before them. But the 11th Circuit did, which I think commendable. Well done. Well done. Thank you for watching another episode of Legal Briefs. Stay tuned for more legal updates.